now head to the jury room where you will receive your instructions. Please follow me. Watch your steps up the stairs.
Perfect. Keep wearing things like that. No more tight sweaters or slacks.
How about no makeup? Like a perfect witch, you know.
That I doubt very much, but this is just right. Oh, and remember, when your husband comes in, give him a kiss.
How big?
Wifely, not too passionate. You want to antagonize the women in the jury, nor arouse the men.
All right, wifely.
Well, good morning, Paul.
Good morning, Mitch.
And how are you today, Mrs. Mannion?
Very well, thank you.
Polly, this is Claude Dancer from the Attorney General's office in Lansing. Paul Beagler. Claude's going to kind of sit in with me during the trial.
How do you do, Beagler? Awfully good to know you.
We fain precede you, Mr. Dancer. I'd like to congratulate you on your brilliant handling of that grand jury investigation in Detroit. I hear you did a fine job.
Thank you. Sure it'll be a pleasure working with you.
I hope it will be a pleasure.
It sure seems nicely on top of his case. I don't think I'll be in your hair much.
Polly, what's a four-letter word describing a woman of your repute?
H-O-R-E. Did you know that, Grover? That's how we spell it here in the UP.
Go to hell, Beagler.
My, Grover. That's a lewd word.
All rise. Hear ye, hear ye, hear ye. The Circuit Court for the County of Iron Cliffs is now in session. Judge Harlan Weaver presiding. Please take your places.
Mr. Clerk, please call in the jury.
Yes, Your Honor.
Jury may be seated. Ladies and gentlemen, for the benefit of those of you who were not here yesterday during jury selection, I am sitting in for your own Judge Maitland, who is currently recovering from illness. Now, I do not intend to change or alter any of the folkways or traditions that you may have here in this community for murder trials. But this is my court, and I intend to run it as such. I did not realize there were so many among you who were such zealous students of homicide. I must remind you, however, that this is a court of law, and not a football game or a prize fight. Mr. Clerk, please call the case.
People versus Frederick Mannion. The charge, murder.
Swear the jury.
People of the jury, rise and raise your right hands. You do solemnly swear that you shall well and truly try and true deliverance make between the people of this state and the prisoner at the bar, whom you shall have in charge, according to the evidence and the laws of this state, so help you God. Amen. Please be seated.
May it please the court, and ladies and gentlemen of the jury, I would like at this time to introduce the gentleman seated at my table, Mr. Claude Dancer, the Assistant Attorney General from the State Capitol in Lansing, who at my request will be associated with me during this trial. Ladies and gentlemen of the jury, the facts in this case are so utterly clear and so utterly incontrovertible that you may find yourself from time to time wondering what you're doing here at all. It is a fact that on the night of Friday, August 15th last, or more precisely the early hours of Saturday, August 16th, the time being 12:46 a.m., the defendant, Lieutenant Frederick Mannion, seated there with his attorney, Mr. Paul Beegler, entered the bar and grill of the Thunder Bay Inn, located in Massillon Township. He advanced to the bar without a single word to anyone. He there fired 6 pistol shots, point blank at the owner, Mr. Barney Quill, who at that moment was standing behind the bar. Of those 6 shots, 5 struck Mr. Quill, killing him instantly. Lieutenant Mannion then walked out of the bar and grill, entered his car, and drove home to the Thunder Bay Trailer Park, where he surrendered himself to the deputized caretaker there, saying, "I just shot Barney Quill." Now, without in any way presuming to speak for the defense, I believe it is safe to say at this time that these facts will not be denied by Mr. Beegler nor his client. We expect to prove that the defendant was sane, and that what he did was done in the heat of passion and anger. We further expect to prove that the killing was premeditated and the result of malice aforethought, as the judge will define those terms. In other words, ladies and gentlemen of the jury, we fully expect to prove, and will prove, that the defendant, Frederick Mannion, was guilty of the crime of first-degree murder. I thank you.
Mr. Beegler, do you wish to make your opening statement now?
Your Honor, the defense will reserve its opening statement until later.
Very well. Mr. Prosecutor, call your first witness.
People call Dr. Homer Rashid.
You do solemnly swear that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. Your name, please.
Homer Rashid,
And what is your business or profession?
medical doctor,
And do you have any specialty, doctor?
pathologist, St. Luke's Hospital, the city.
And where did you receive your medical education, doctor?
The doctor's seminar qualifications are admitted.
Did you have occasion to perform an autopsy on the body of one Barney Quill?
I did.
And what were your findings?
I made up an autopsy report.
Unless Mr. Beegler objects, a summary will do in lay terms.
Well, there were multiple and perforating wounds of the body such as might be caused by bullets. All in all, there were 10 such wounds, as though 5 bullets had entered and left.
Were you able to determine a cause of death?
I was.
And could death have been caused by these wounds you've testified to?
They could. I mean, it could.
In your opinion, doctor, was death caused by these wounds?
Yes, in my opinion, a wound through the thorax and heart was the immediate and major cause of death. The other wounds, of course, contributed to death.
And have you a typewritten report of your findings?
I have. Also some copies here.
May I have it? Ask that this original autopsy report be identified as People's Exhibit 1. I submit a copy of that exhibit to the defense for examination. people offer into evidence People's Exhibit 1 to be identified as People's Exhibit 1.
You may be so received and marked.
You may examine.
Doctor, you said that it appeared that Barney Quill had been shot 5 times with bullets from a gun.
It did.
And also that each of these shots had plowed through him, as a layman might say, and come out the other side.
That is correct.
Like a layman might even say that the deceased was well ventilated.
Precisely.
So I take it you didn't find any bullets.
No, I mentioned that in my report.
Yes, I noticed that. But your conclusion that these wounds were caused by bullets was more or less a surmise, was it not?
Well, in a sense, yes.
Well, you knew when you did this autopsy that the deceased had been shot by the defendant in a bar room.
Yes.
That information and other information had been provided to you by Coroner Lippert and the officers who had requested the autopsy.
Well, yes, from them and from reading the newspaper, of course.
Well, the officers gave you certain background information before you did your post-mortem.
That's correct.
So, to an extent, your explanations were suggested by information that you received from them.
Yes, but my primary purpose was to determine the cause of death, and I did determine it. I didn't need any information from anybody to do that.
No, of course not, Doctor. You made it quite clear that the deceased was well drilled. So, what I want to know then is, how come you checked to see whether spermatogenesis was ongoing in his testes?
I object
On what grounds, Mr. Dancer?
on the grounds of incompetency and immateriality. People have called this witness to show the cause of death. He has shown it. Cross-examination should be confined to that issue.
Mr. Biegler?
Your Honor, I note the doctor's report under the heading of general findings on the top of page 5. Where I quote, spermatogenesis was occurring in both testes, unquote. Now, this is contained within the People's Autopsy Report, and this report has already been admitted into evidence in this case. I think I'm entitled to inquire into anything that's contained within their report.
Objection overruled. Answer the question.
You can venture an answer now, Doctor. The coast is clear.
I made the check because they asked me to.
Who asked you to?
The officers present.
I see. Now, did you know that when you made your test, another doctor had taken a smear from the defendant's wife and reported it negative for spermatosis?
I did.
Objection. It's based on hearsay. Irrelevant.
You're a little late, Mr. Dancer. The question seems to have already been answered.
Well, then I move that the answer be stricken and the jury instructed to disregard both the question and the answer.
Motion denied. Proceed, Mr. Biegler.
So that portion of your examination had nothing to do with determining the cause of death.
Nothing whatever.
On the other hand, the question whoever raised as to whether a man had had intercourse with a woman who said he had, and the smear on the woman was negative for sperm, whereas the test on the man was positive for the presence of seminal sperm, all of that might be evidence that they had not had intercourse. Is that correct?
Objection.
Overruled.
Yes.
So if the question never came up at some other time, say during a murder trial, no one could ever question, not even a defense attorney, that the absence of sperm in the woman was caused by the absence of sperm in the man.
I suppose that's true. I assume then, as I do now, that that was the main purpose of their request.
Now, doctor, were you asked to make a determination and an examination if the deceased had recently had intercourse and reached a sexual climax?
I was not.
If you'd been asked to, could the test have given you the result?
It should have.
But you weren't asked to and you didn't.
Correct.
A couple more questions, doctor. We're almost done. Did you make a test to determine the blood alcohol content of the deceased?
I did not.
Were you asked to?
No.
If you'd been asked to, could you have done so?
Very easily.
Further questions?
Any redirect?
No further questions, Your Honor.
That is all, Doctor. You may go.
Miss Anna Burke.
You do solemnly swear that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Your name, please, ma'am.
Hannah Burke.
And what is your occupation, Miss Burke?
I am a commercial photographer with a studio here in Iron Bay.
Now, were you employed by the police in the early hours of Saturday, August 16th to take some photographs at the Thunder Bay Inn Bar and Grill?
I was.
Do you have these photographs with you?
I do.
And are they of the deceased Barney Quill?
They are.
Could you identify them for us, please?
These three were taken behind the bar and showed the deceased lying on the floor. These four were taken at the coroner's office and showed the deceased full length, full face, left and right profiles.
Submit these photographs to the defense for their examination.
And the defense compliments Ms. Burke on her artistry. We have no objection.
The people offer these photographs into evidence.
They may be so received and marked.
You may examine.
We have no question. One moment, please. Ms. Burke, are these all of the pictures you took that night for this one?
No, there were some others.
Oh. Perhaps they didn't turn out.
No, they all turned out. All of my pictures turned out.
Well, perhaps they were needless duplicates.
There weren't any duplicate poses.
Maybe they were taken for some purpose different altogether. Maybe some artistic whim. A gnarled tree stump that you couldn't resist, or maybe a bear rummaging around at the dump. Or perhaps they were pictures of a woman.
They were photographs of Lieutenant Manning's wife.
And these photos of Laura Mannion, they turned out well?
Excellent.
And when did you take them?
That very night.
So these pictures would show how Mrs. Mannion looked right after the shooting.
They certainly would.
And how many are there?
3.
Do you have them with you? Come, Miss Burke, you either have them or you don't.
I have them.
May I see them? Oh, my. These dark circles under her eyes, the result of bad lighting?
No, sir. Miss Mannion had 2 black eyes.
And this smudged lump on her cheek? A little problem with the darkroom, perhaps?
No, sir. She had a terrible bruise.
Your Honor, all this is irrelevant.
Well, don't you think, Mr. Dancer, that the jury had a chance to see these?
Well, they're plainly irrelevant and a matter of defense if admissible at all, which I doubt.
Well, this is your witness and your photographs. I can't introduce them into evidence.
The people insist they are irrelevant.
Well, are you afraid to have the jury see these pictures?
Come, Mr. Beegler, either the people will offer the pictures in evidence or they won't. Mr. Dancer?
People offer these photos into evidence along with those of the deceased.
In that case, I have no further questions.
They may be marked and entered. Any redirect?
No further questions.
You may step down.
Your Honor, the defense notices that a third person has joined counsel at the prosecutor's table and wonders whether the court shares our curiosity as to his identity and function.
Your Honor, the gentleman seated at our table is Dr. W. Harcourt Gregory, the people's psychiatrist in this case. We were about to identify him and request the court's permission that he be allowed to sit at the prosecution table as an observer during the case when the defense counsel, with characteristic bravado and corn, jumped the gun and tried to make a grandstand play of it. We now respectfully make the identification at request.
Mr. Beegler?
Well, the defense apologizes for its bad taste and peasant curiosity about the gentleman's identification, but nevertheless inquires of the people just what it is that they want him to observe.
To observe the defendant, as indefatigably grandstanding counsel well knows.
Well, the ball's back to you, Mr. Beegler.
In that case, Your Honor, the defense has no objections. For a minute there, we just thought Lansing had rushed in additional legal reinforcements on behalf of the people.
The people's request request is granted, and now that you gentlemen have had your setting up exercises, can we get on with this trial?
Your Honor, there are 7 other eyewitnesses to the shooting endorsed on the information, to whom the sheriff has not been able to serve subpoenas on because they have left the state. For defense counsel's information, I might add that 3 of them were soldiers stationed near Thunder Bay and now in Georgia, and the other 4 were tourists residing out of state.
Mr. Biegler?
The defense inquires of the people as to these other people have been interviewed before they left, and if so, would they have given largely cumulative testimony that would be cumulative to the testimony of the witnesses who have or will testify in the trial?
All 7 eyewitnesses were interviewed, and we represent on the record that their testimony would be largely cumulative.
In that case, Your Honor, the defense waives production of these witnesses and any cross-examination of them. We do that because there is not now, nor has there ever been, any dispute over the fact that Barney Quill died as a result of being shot by Lieutenant Mannion. We simply dispute that it was murder.
There's no need for counsel to make a speech. Either he waives or he doesn't waive.
Very well, gentlemen. One speech doesn't deserve another. Call your next witness.
People call Alphonse Paquette.
Left hand on the Bible, raise your right hand. You do solemnly swear that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You may sit down.
Thank you, Your Honor.
State your name, please.
Alphonse Paquette,
And where do you live?
Thunder Bay, Michigan.
Where do you work?
Thunder Bay Inn.
In what capacity?
I'm a bartender at the New Lake Superior Cocktail Lounge and Bar.
Were you on duty the night of Friday, August 15th and early hours of Saturday, August 16th this year?
Yeah, I was.
And did you know the deceased Barney Quill during his lifetime?
Yes.
How long?
About a year and a half. I've worked for him that long. He's my boss.
And did you know the defendant, Frederick Mannion, prior to that evening?
I did.
How long?
About 3 weeks. He used to come into the bar.
And could you identify in this courtroom the man you know as Lieutenant Mannion?
The guy standing over there in the Army uniform.
Now, were you in the bar at the time of the shooting?
Yep, I was.
Did you see the actual shooting?
No.
Did you hear it?
Yeah, I heard about 6 shots fired. When I looked over, I saw a guy in an Army fatigue jacket bending over the bar.
Then what?
Well, then the guy raised up and walked out the door near where I stood.
Did you recognize him?
I wasn't sure.
Well, what did you do then?
I rushed out the door after him.
And were you able to recognize him outside?
Yeah, I was. He turned and faced me, and I recognized him.
Who was the man that faced you?
Lieutenant Mannion.
Your witness, Mr. Beaver.
Mr. Paquette, did you say anything to Lieutenant Mannion when you rushed out after him, as you so dramatically described it?
Yeah, I said Lieutenant Mannion.
I see. And this is the man that you just testified you weren't sure that you recognized.
Yeah.
Well, was the light in the bar helping you to identify him and call him by name?
Well, I guessed it was him.
That's not what I asked. I asked, was the light helping you?
No.
Now, it's no secret that some dozen odd casual patrons correctly identified the lieutenant, but you, who were standing by the door both when he came in and when he went out, you weren't sure of who he was.
That's right.
All right. Now, what, if anything, did the lieutenant do when you called him by name?
He whirled around.
And this is when you were able to confirm your shrewd guess as to who he was.
That's right.
And did he say anything?
Yes.
Would you please tell us what it was he said?
He said, "Do you want some two-buster?"
And he was pointing his gun at you.
Yeah, I think so.
His empty gun.
I didn't know it was empty then.
Well, you heard 6 shots. Was he pointing a Tommy gun?
I don't know guns. Mr. Quill, he was the expert, not me.
Ah, Mr. Quill was the expert, I see. Now, I assume that you told your story of the incident that night to the police
Yeah,
and to Prosecutor Lodwick
yeah.
and his part-time helper, Mr. Claude Dancer.
Yeah,
And I also assume that you told all of them what you've told me here today, namely that the lieutenant whirled around and said, you want some two busters.
Objection. Defense counsel is trying to imply that the prosecution is attempting to hide something. The only reason we didn't bring it out was that it might create error or a mistrial, being possible evidence of still another criminal offense committed by the defendant.
The defense is touched by your solicitude for the defendant's well-being, Mr. Dancer, but you've only blown up this courtroom and everybody in it to get that out if I hadn't.
Come, gentlemen, I'll take the answer.
yeah, I told him all about it.
And when did you tell Mr. Dancer?
Last night and again this morning.
And did he or anyone else tell you not to mention this buster business for fear that it was error might possibly harm the lieutenant's best interests?
No, I don't think the subject came up.
Uh-huh. Mr. Paquette, as a bartender, what do you call your cheaper brands of whiskey?
Oh, well, pile run or cooking whiskey or sometimes rat poison, you know, slang names like that.
Slang names like that, I see. How about your bonded bourbon?
Just bonded bourbon or sometimes white vest stuff.
I see. And what do you call a man who has an insatiable penchant for women, any and all women?
What's pension?
Desire, hunger, taste. Yeah.
Oh, well, I guess a ladies' man or maybe just a damn fool.
Anything else?
Your Honor, we don't see the drift of all this.
You mean you do see the drift of it, Mr. Dancer?
Proceed, gentlemen, proceed.
Anything else?
Woman chaser?
Oh, pretty medieval. Try again.
Masher.
Oh, Mr. Paquette, Masher went out with whalebone corsets and hairnets, but you're getting warmer. Anything else?
No, sir. I haven't had the educational advantages that you've had.
Well, how about Bull? Have you heard of that one, or do you let you shelter the life? Have you ever heard of that?
Naturally, I've heard it. It just slipped my mind.
I see. I can see why that can happen, you know, banging around inside that head of yours with all those rusty old mashers. I can see why that can happen. Now, you use the expression yourself.
Of course I have. Everybody does.
And what does it mean?
It's like you said, you know, bear cat for women.
Have you used the expression lately?
I couldn't remember that any more than you could.
Well, let me see if I can refresh your memory. On the Sunday after the shooting, you were driving into Iron Bay, and Mrs. Manning heard that you were going and asked you for a ride. She wanted to come into town to see her husband at the jail. You were kind enough to give her a ride. Now, do you recall that? You needn't look at Mr. Dancer. I don't believe he was hunting the Upper Peninsula at that time.
Let the witness answer. Don't try to pretend he's being evasive.
Not pretending.
I suggest that both of you gentlemen invoke a little silence. Let the witness answer the question. In fact, I order you to. Proceed.
Yeah, I remember.
And do you remember what you said to her and what she said to you?
Well, we talked about, you know, the weather, the traffic, things like that. Nothing important.
The weather and the traffic. Nothing beyond that.
Look, her husband had just shot my boss. What was I supposed to talk about? That? I gave her a lift. I did her a favor, that's all.
Very well. That's the way you want to leave it. Now, you knew Barney Quill quite well during his life. Is that correct?
Yeah.
Quite intimately.
Yes.
And would you consider to a certain extent, would you consider yourself to be his confidant?
Yeah.
And were you able to tell when he'd been drinking heavily?
Objection. There's nothing in this case involving drinking. Had the deceased been dead drunk, there'd still be no defense to this charge. I see no connection there.
The objection could possibly be well taken, but I will let the witness answer the question.
I wouldn't say he was drinking heavily that night.
That's not what I asked. I asked, could you tell when he was drinking heavily?
Yes.
And was he drinking heavily that night?
No.
No. How about that day?
No.
Well, how much was he drinking when he was drinking heavily?
I object. The witness has said that the deceased was not drinking heavily that day, which is the only day that concerns us. I see no connection or relevancy here.
Well, you're pushing this pretty far, Mr. Beegler. I'll let the witness answer the question, but the limit is near.
I'll withdraw the question. Now, based on your intimate knowledge of the deceased, could you tell us how you knew that Barney Quill was an expert shot.
Objection. There's no self-defense in this case. All facts point to the defendant being the aggressor. It's immaterial and irrelevant.
Your Honor, we believe that this is material and relevant and is linked to several important issues in the case, but we will, of course, abide by the court's rule.
I believe I must sustain the objection. If and when whatever issues you have in mind should be properly raised here, I'll allow both sides to go sled length, but not until then. That is my ruling.
Your Honor, it may be understood that I might have further cross-examination of this witness when and if that issue is properly raised.
It may be so understood, and I so rule.
In that case, Your Honor, I have no further questions of this witness at this time.
Any redirect?
No further questions.
Mr. Biegler?
Yes, there is one more thing, Your Honor. I think it's time that the defense objects to certain objectionable practices of the prosecution. This witness, for example, the one that's on the stand, started out being Mr. Lodwick's witness. Then I took over, and Mr. Lodwick was hastily retired to the showers, and Mr. Dancer rolled in the heavy artillery of objections. And when I'm done with him, well, Mr. Dancer forgets all pretense that this was ever Mr. Lodwick's witness to start with, and he says he has no further questions. Now, I'm perfectly willing to take on either one of these legal giants anywhere, any place. But in all common fairness, it ought to be one at a time.
Your objection is well taken, Mr. Biegler, and I've been waiting for you to raise it. And I'll lay down a rule on that. Only one counsel at a time will be able to examine a given witness. And now this witness may step down. Gentlemen, normally I insist that counsel arise and remain standing when examining a given witness or addressing the court. But given the expanding length of this trial and its rather uncertain length and hectic pace, I'm going to suspend that requirement. Are there any objections?
None.
The defense is delighted and grateful, Your Honor.
Call your next witness.
People call Detective Sergeant Julian Durgan.
You do solemnly swear that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Your name?
Julian Durgo,
Your address?
471 River Street, Iron Bay, Michigan.
Are you a plainclothes detective in the state police?
I am.
How long have you held that position?
14 years.
Did you have the occasion to investigate the fatal shooting of Barney Quill?
I did. I headed the investigation.
Were you the one who arrested Lieutenant Mannion later that night in his trailer?
I was.
Did you discuss the shooting then or later with him?
I did, both then and later.
Can you tell us what he said?
I asked the lieutenant where the gun was, and he pointed at a table and said that he would get it. But I said no, and instead got it myself.
And is this the gun?
It is.
No objection.
People submit this as People's Exhibit number 3.
May be so marked and entered.
Were you present at the bar when an effort was made to recover the bullets?
I was. I conducted the search.
And were any recovered?
4 bullets were found along with the shell cases.
Did you preserve and do you now have these bullets and shell cases?
I did, and I have.
And are these the bullets that killed Barney Quill?
They are the lead pellets we found in the barroom, sir.
I now hand you defense counsel for inspection the bullets that killed Barney Quill.
Well, thank you, Mr. Dancer. I've seen bullets before. Taken from the body of a deer hunter, a fellow about your size.
Exhibit may be entered and marked.
Now, getting back to the defendant at his trailer, what, if anything else, did he say?
He said that his wife had some trouble with Barney Quill, and he'd gone and shot him. He also asked us whether the man was dead.
And what then?
Then we drove him and his wife to the county jail.
Was there any further discussion with the defendant in the car on the drive down?
Yes. On the drive down, the lieutenant said that he had thought the whole thing over before going to the bar and had decided that such a man should not live.
How did the defendant appear?
He was upset and emotional and appeared very angry.
What else?
He said that he had no regrets over what he'd done, that he would do it again. Several times more, he asked us whether the deceased was really dead.
And then?
Then we arrived at the jail, and I asked the defendant whether he cared to make a formal statement. He said no. Then he was booked on murder and locked up, and we returned immediately to Thunder Bay to continue the investigation.
Your witness?
Officer, I believe you testified on direct examination that Lieutenant Mannion told you that he had shot Barney Quill after he had learned from his wife that she had had some trouble with the deceased.
I did, sir.
Now, are those his words, some trouble, or those your words that are used here today to describe what he told you?
They are my words, sir. I don't believe the lieutenant used that expression.
Would you now please tell this court and this jury just what it was that the lieutenant told you about this trouble?
Yes, sir.
Objection, Your Honor. This would not be relevant to any issues that have been
Officer, what are you trying to do? Railroad this poor
Mr.
guy?
Ziegler,
Please not mention
Mr.
anything so
Ziegler,
nasty.
Mr. Ziegler, I must warn you against such outrage in this courtroom. You are an experienced lawyer and you know better, much better. If you have any comments to make on any objections in this court, you will address them to me. I will not permit such intemperate display here today. The only reason I'm overlooking this one is that I realize you men are under such a strain.
I'm sorry, Your Honor, and I do apologize to the court. Your Honor, I would like to address my comments with the objection, if I may. This witness is a key witness for the people. He's investigated this alleged murder and given testimony here today which, if unexplained or not explored further, could potentially be most harmful to this defendant. I think and I insist that we have the right now, while this decidedly one-sided impact of this testimony is fresh before the jury, to learn all that he knows, everything that the defendant and his wife told him. Insanity is an issue in this case. And we suggest that whatever trouble the defendant's wife had with Barney Quill triggered, or at least contributed to that claimed insanity. We only seek to find out what that trouble was. Did Barney call her a bad name or cheater at pinball? It must be apparent even on the face of it, just to a trial, that the defendant obviously said more than that to Officer Durgo if he said anything at all. And the fact that he said something, this witness has already testified. I urge with the utmost seriousness that we be allowed to find out what that trouble was now, here, and not later, when this testimony's been allowed to gel. It would be a pity to inject reversible error into this case at this point in the trial.
I will take the answer.
The defendant told us that the deceased had raped his wife.
Now, officer, without going into detail, did you ask Laura Mannion, and did she tell you that Barney Quill had raped her?
I asked her, and she told me.
In great detail?
In great detail.
And did she tell you that it happened in the woods across from the main road?
Yes, sir.
And about a second attack, which happened at the Tourist Park gate, where she escaped and then was assaulted again and screamed and then finally escaped.
She did, sir.
And did she take you officers to the side road in the woods where the first assault was alleged to have occurred?
Yes, sir.
And did you find dog tracks and tire marks and burn marks on the road there?
Yes, sir.
And look for her panties, but couldn't find them?
Correct, sir.
And is this the some trouble that the lieutenant referred to?
It was.
Officer, was it your notion to come in here today to this court and call it that?
It was not, sir.
Was the suggestion to call it that made by somebody who's in the room?
He is, sir.
Well, officer, did you conduct an independent independent investigation then and later about the allegations of this rape?
I did, an extensive one.
And did your investigation tend to confirm or refute Mrs. Mannion's story of the rape?
Confirm it, sir,
In every particular?
in every particular.
You long ago turned this information over to the prosecution.
Yes, sir.
Now, officer, I ask you, are you an expert pistol shot?
Well, sir, yes, I guess I am.
You're familiar with pistols and ammunition?
I believe I am, sir.
Do you ever engage in pistol shoots with individuals who are not in law enforcement?
Occasionally.
In this county?
Yes, sir.
And was one of those individuals the deceased Barney Quill?
Yes, sir.
And was he an expert pistol shot?
Yes, sir. I would say he was among the best I have ever seen.
Are you familiar with this type of weapon?
I am, sir. It's a German Mauser 25 caliber automatic.
What happens when it's empty?
Well, without getting technical, the gun stays open, this gadget goes up, and the trigger clicks loose, like this.
So an individual who's familiar with this type of weapon could tell that it was empty just by looking at it without having to open it.
Correct.
Thank you. Now, officer, did anyone besides you question Mrs. Manning?
Lieutenant Peterhouse did, sir.
What does he do? I don't recall seeing his name on the information nor mentioned before in this case.
He's our expert on the polygraph.
And what is the polygraph?
Well, it's generally known as a lie detector, sir.
You mean Mrs. Manning was given a lie detector test?
Objection. Results of the polygraph are never admissible in our courts, as counsel well knows.
I'm not looking for the results of the test, Your Honor, merely the fact that one was given.
I will take the answer.
She was given such a test, yes.
And was she given this test before or after you independently determined that she'd been telling the truth about the rape?
After.
At whose suggestion?
Mrs. Mannion's.
And after the test, had your mind changed on that score?
Your Honor, this is clearly a subterfuge to get around the rules barring admissibility of polygraph tests. The defense counsel has never asked us for the results of
Well,
these
we're
tests.
asking for it now, Mr. Dancer.
Gentlemen, there has been a question and an objection, and I must make a ruling, which I cannot do as long as you keep up this unholy wrangling. Now, I realize we are skating on thin ice here, but in all conscience, I cannot rule against the question. Counsel is not asking for the results of the polygraph, but rather an opinion from the witness based on knowledge and information that he has. You may answer the question.
My mind did not change.
So before the test, you thought she was telling the truth?
Yes, sir.
And after?
Yes, sir.
And even today?
Yes, sir.
Finally, officer, isn't that the real reason that you didn't ask Dr. Rashid during the autopsy to determine whether Barney Quill had recently had intercourse or the blood, the alcohol content of the body?
Yes, sir.
You and your organization were already convinced beyond any question of the truthfulness of this rape, and no further confirmation was necessary.
Precisely, sir.
Did the question ever come up at that time that any question would be raised or fact made up of this rape having taken place, least of all by the prosecution?
It certainly did not, sir.
No further questions.
Any redirect?
No further questions, Your Honor. The witness is excused.
You may step down. Mr. Dancer, can I ask how many more witnesses you are prepared to call here today?
People are prepared to call Coroner Library, Mr. Carl Yates, and Mr. Peterson, who were witnesses to the murder, as well as Mr. Lemon, the caretaker of the Thunder Bay Trailer Park, and the individual to whom the defendant surrendered.
Since the testimony of these witnesses, along with any redirect examination, will probably take considerable time, I think we will adjourn this trial for today. Court is adjourned until 9 a.m. tomorrow morning.
Congratulations, Polly. You finally got the lady laid.